Much for staying with us. This is Politics Tonight, and I've been speaking with John Matthew, Abuja-based legal practitioner and PDP lawyer, tonight to discuss the Nasarawa State Governorship Election Petitions Tribunal, which declared PDP candidate winner. Mr. Matthew, go on with our submission and also tell us the tribunal's position on that.
Thank you very much. Like I said, the powers to cancel election results at the polling units for any reason resides with the presiding officers. And the law provides that where a presiding officer comes to the determination that the result of his polling unit ought to be cancelled, he has a right to do so, but he must make a report as to why he cancelled the result and fill a form called Form EC40GPU and bring this to the ward collation officer, who will also now fill another form called for EC40G, which will now be taken to the next step, up to the final collation. Now, there was no Form EC40GPU filled by any of the 35 presiding officers who brought in their results. In fact, the results of the various polling units were indeed collated into a B summary by the ward collation officer, who for inexplicable reasons subsequently now claimed he cancelled the results. And the Form EC40G that he filled did not contain the names of any of the polling units comprised in the ward. Now, the most baffling of all things, the most baffling, I should say, explain this to you, is that the governorship elections took place contemporaneously with the State House of Assembly elections. The results of the State House of Assembly elections for that constituency where Ashige is part of was actually declared with Ashige. So, by what magic could there have been violence in respect of elections for governorship and no violence in respect of election for State House of Assembly? So the tribunal did not buy what the respondents were trying to say, because the evidence was overwhelming that no election was cancelled. And in fact, the final declaration of result done by the state returning officer also has a Form EC40G, which 40G2, which he filled in respect of any polling unit in the entire state where there was cancellation. Surprisingly, no Ashige was featured in that form. So the tribunal had no difficulty in saying that no, this was an afterthought, and restored the result for both parties.
All right. Thank you for that. But you would agree with me that it's still a long way to go, as Governor Sule decided to appeal the verdict. So how worried are you about the task ahead?
Like I said, every appeal is by way of a rehearing. It's not going to be one that will necessitate the calling of any fresh evidence. It's going to be based on what has been done. We are satisfied that both in respect of the facts and the law were on what, as lawyers will call, firmer terra. That is, we are quite satisfied that these findings of the tribunal will be sustained up to the Supreme Court. The governor has 21 days from the 2nd of October to file this appeal. If he does not exercise that right, then we'll be in Government House to remove him from there. But if he does exercise his right of appeal, we have a right to meet him up there. He has a right to ventilate. He's gone through that route before. In those previous situations, he was always a respondent. Now he will see what it feels like to be an appellant. We are prepared and we are confident that what the tribunal did will be sustained up to the Supreme Court.
So we've seen people win at lower tribunals but fail to win at the Superior Court, rather. So what gives you this confidence that they will win this appeal?
Sorry, I didn't get the last.
As an experienced lawyer, and from this end, I said we've seen people win at lower tribunals and fail to win in the Superior Court. So I'm asking, what gives you this confidence that you will win this appeal?
My confidence stems from the records of what transpired at the lower tribunal. Like I said, an appeal is by way of rehearing. It is not going to, they are not going to go, the appellate court is not going to go outside anything new. It is going to review what was done, the evidence that was placed before their lordships at the lower tribunal. It is going to review the application of the law to those facts. And like I keep on harping, our position at the lower tribunal was to present the facts and the law as it is, as it applies to them. Whereas the other side was hinging basically on technicalities. And the key areas they were hinging on these technicalities are areas that have already been settled in a plethora of judicial authorities. And so we are confident that the law is not going to change overnight in their favor. It's not. This is a case that is rooted in justice. This is a case that is as plain as anyone to see. And like I repeated for the umpteenth time, that the election results indeed, up till this minute that I speak, is there in the IREF. Any discerning mind can download these results and do a computation, and you'll come to a determination that we indeed won this election, and ought to have been sworn in. Not by this, and I just pray that our National Assembly will take a look at this practice of not concluding litigation before swearing in people who are not deserving of being in those offices. But as it is the law now, we are patient enough. We've advised our client, and our client has briefed us to be ready to welcome whatever appellate processes will be served and to respond to it adequately. And I want to assure you we have a formidable team of lawyers. More are even joining us out of sympathy with what has happened in the election itself, and out of also joy that a tribunal has the courage of their conviction to see facts and to act on it and do the right thing, like their lordships have done in a majority judgment in this case. I want to end this by restating again that the about turn that the dissenting judge did, having delivered a judgment in one way in a case, and the next few minutes doing an about turn in another, is quite baffling. I doubt if he really understood, he really appreciated the enormity of what he was doing. He has a right to do so, but even as a human being, you don't have to be a lawyer to understand that somebody says something in... Yes, please.
I get that. But another interesting aspect of that judgment was that the lead was delivered virtually. Has this come to stay in our judiciary, and what do you think is the implication?
I doubt if there is anything wrong with that judgment being delivered in the manner in which it was delivered. We have had instances of even tribunals entirely being relocated. I was privileged to participate in the governorship tribunal for Ebonyi State. We sat in Abuja here throughout those proceedings. So circumstances perhaps warranted the tribunal sitting virtually, where, for example, what led to bringing tribunals from the east to Abuja is perhaps having to do with the state of security in those areas. In Nasarawa State, of course, there is understandably palpable tension by both sides. And so I think the tribunal decided to deliver its judgment virtually, as they are entitled to, by ensuring that they also took care of their safety. So I don't think there's anything wrong with that. At least they were able to deliver majority and dissenting judgment. And everybody, in fact, I would like to let you know that the deputy governor of the state was present in person when the judgment was being rendered. And two predecessors of office, two previous governors, in the name of Abdullah Adamu and His Excellency Umaru Tanko were present in court to also listen to this judgment.
Right.
So it was a judgment that was delivered in an open manner, and everybody listened to it, and I don't think there's a problem.
All right, then. So let's move on to other issues outside of this judgment, and that's because you're a lawyer, it's very important to have your take on this. I want us to talk about intimidation of the judiciary through social media. What's your take on that?
I think it is really, really, really unfortunate and must be deprecated by any right-thinking person. Judicial officers are performing very onerous and important responsibilities by adjudicating through, between parties that are in disagreement. It is unfortunate for any right-thinking person to want to either wittingly or unwittingly cast aspersion on their lordships in social media or by whatever means. There are avenues to ventilate grievances, and happily, the law has provided for appellate processes if you are not satisfied with the judgment of a court. But to go to social media and cast aspersion at their lordships is totally, totally uncalled for. And as a legal practitioner, no matter what side of it, I've sat and listened to judgments where they have dismissed my cases before. And I bow and say, as your lordship pleases, what I have a responsibility to do is to go on appeal. So I appeal to our colleagues to rein in their supporters and educate them that their lordships who may have given a judgment against you today may be the one who will give judgment for you tomorrow.
All right. So this is another very important issue. Our elections continue to be trailed by litigation. As a lawyer, what impact do you think this will have on the country's democracy?
The initial aspect of your question.
Did you get my question? Okay, let me repeat myself. Our elections continue to be trailed by litigation. So I'm asking, as a lawyer, what impact do you think this will have on our country's democracy?
Well, I would say that if there were no problems, we won't have this much litigations in court. The Electoral Act, the National Assembly did a lot of good work in trying to improve the Electoral Act. Unfortunately, the problem was taken off the street, from the ballot box where we normally have litigation issues arising, now to the doorstep of INEC. The greatest, in my opinion, the greatest culprit in this election cycle is really the role played by the Independent National Electoral Commission. Most of the litigations you will find do not have anything to do with fighting at the polling units, snatching of ballot boxes at the polling units. These ones, we've gone past that. But in computing, in entries, and these things are done by INEC. So I think to be able to reduce these incidences that will lead to election litigation, necessary sanctions that are available on our statute book must be enforced to the latter. If you are engaged, even as an INEC staff, even as an ad hoc staff, and there is brazen case of violation of... In
that regard, what more reforms do you think Nigeria needs to bring sanity to the electoral process?
Well, first and foremost, I think we have we've started deploying technology in our electoral process. We ought to go a step further. I would call that the present National Assembly should look very seriously at the possibility of electronic voting, so that people can sit even in the comfort of their houses and vote. The Nigerian Bar Association has gone that step already. We vote in our national election from the comfort of our homes, from your phone. So we should be able to take a critical look at electronic voting. The deployment of the beaver machines has gone a very long way in reducing the incidence of electoral manipulation. But it is being circumvented by the wrong entries of figures that are presented before you, by election officers refusing to follow their own rules. So the searchlight must be beamed on them to ensure that they follow their own guidelines in the electoral process.
Thank you. Thank you so much. I've been speaking with John Matthew, Abuja-based legal practitioner and PDP lawyer, tonight to discuss Nasarawa State Governorship Election Petitions Tribunal. Thank you so much, Mr. Matthew, for coming on Politics Tonight, and please have a great weekend.
Thank you for having me.
And that marks the end of today's episode of Politics Tonight. But the conversation continues from here. Get in touch with us on Twitter at TVC News NG and at Olajumoke using the hashtag Politics Tonight. We're also on YouTube at youtube.com/TVC News Nigeria. I am Olajumoke Olatiji. Bye.